morning with your sovereign citizen argument? You needed some additional time to prepare?
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
Next matter is State of Kansas versus Gordon Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand.
All right, everyone, buckle up because today's video is a wild ride straight from two very different courts, Kansas and Florida. On one hand, we have Gordon Cooley, a sovereign citizen who believes the law doesn't apply to him, showing up unprepared and already fighting reality before even hearing the charges. And on the other, we've got Satavius Morris in Florida, taking sovereign arguments to a whole new, almost surreal level. These are moments where patience, procedure, and plain old common sense clash with fantasy legal theories. Stick around, because the level of courtroom chaos is next level, and the drama is just getting started.
Question in regards to what you're charged with.
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights. And I stated that to the man acting as the police officer. I didn't present him with a license.
You are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
Have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney counsel, would he qualify under any programs you have since you charge this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plea. I guess I'll answer in affirmative, but Demers is not acquiesced to quasi.
If you're not going to enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or law.
Mr. Cooley, if you wish to have a trial by jury.
I'm Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question, sir?
You need to be quiet for a moment, and I'm going to explain what the situation is. You have the right to be represented by counsel. You entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
That's the thing with sovereign citizens. No matter how confidently they argue, the law doesn't bend to personal belief. Notice how Cooley openly admits he doesn't understand the charges. This is textbook. Denying the law won't make it disappear. It's almost like watching someone play a video game without reading the instructions. They're confused, frustrated, and surprised when reality hits. And yet, the judge calmly explains the stakes: a year in jail, fines, and mandatory minimums. This is where legal reality meets fantastical thinking, and Cooley is about to find out just how unbending the system can be.
When they have harmed no man or woman, no
Mr.
claim
Cooley,
has been brought
Mr. Cooley,
against them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
At
Judge,
2:30?
I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial for an hour, didn't we? So
If you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will invoke my common law right.
Where it gets truly bizarre, Cooley refuses to enter a formal plea, so the court has to step in and enter a not guilty plea on his behalf. Standing mute might sound dramatic, even rebellious, but in legal terms, it's essentially a non-move. The court simply keeps the process moving. And his insistence on facing the man or the woman he supposedly harmed. Classic sovereign logic. It's almost theatrical, but the tension here is real. Judges have seen it countless times, yet each encounter is a test of patience and precision.
Habeas Morris.
I'll come to the jail and talk to you.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, it was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23-174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer Henry Mark Sims to represent you in the 24 case.
I go state this to the court.
Raise your right hand and
Yes.
now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen.
Cooley now wants to represent himself and demands a jury trial. But as the judge points out, there's a procedure for that. The law doesn't just let you improvise. Self-representation can be tempting for someone who thinks the system is against them. But the reality is, without formal training, navigating a trial is almost impossible. It's fascinating to watch sovereign citizens push boundaries here, asserting rights they may not fully understand, challenging legal norms, and testing the patience of the court. For viewers, this is where drama and education intersect, showing exactly why procedure matters.
Something about a secured.
My name is Alize Morris, a secured party creditor under the UCC-1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States. Not a record. So documentation, which is official records. To state it, I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory.
Okay. Tell me what the 14th Amendment says.
That you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This, if you commit a crime.
Okay. Doesn't say if you commit a crime.
Or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's because it's an amendment to the U.S. Constitution.
Mm-hmm.
So you don't know what the 14th Amendment reads?
The 14th Amendment reads not off on the top. Not off.
Okay.
That's why I read.
What else do you want me to consider?
That I'm a secure party creditor under the UCC-1.
Tell me what the UCC-1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC-1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC-1 reads.
It's a statement and it's a financial.
You don't know what the UCC-1 reads, do you?
Not on top.
You're not prepared. You're not prepared this morning with your sovereign citizen argument. You needed some additional time to prepare.
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
This is one of those moments that's equal parts comical and serious. Cooley questions the authority of police officers, claiming no man or woman has the right to imprison him. And while it might feel like a deep philosophical debate, in practice, the law is clear. Judges repeatedly have to remind these defendants. Personal belief doesn't override statutes. The courtroom becomes a theater for sovereign arguments. But there's a reason courts follow strict rules. because justice relies on order, not imagination. And viewers, take note. These moments highlight how quickly fantasy can collide with reality.
I would ask that he's got 2 cases. I know one we've got already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I mean, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here. What is
Coming
state?
back.
we're going to May 9th
Okay.
at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
going to
sir.
come back.
Just making sure.
You're fine. I'm not going to query you about what a contract is, but we'll talk about whatever you want me to consider next time. Take care.
Is Braden Sandell, 2300418SM.
Andrea McCray appearing on behalf of the people.
Patrick O'Keefe on behalf of Mr. Sandell.
And you, sir, you're Braden Sandell. And keep your voice up so we can record you.
Yes, ma'am.
Thank you. Today is the date for sentencing. We had a trial in this matter where the defendant was found guilty. We have a pre-sentence report with recommendations. Mr. O'Keefe, you've been able to go over that with the client?
Yes, I have, Your Honor.
Additions, deletions, corrections to the factual content?
We have none, Your Honor.
Ms. McCray, you did enter your appearance today. Do the people have anything for sentencing?
No, I mean, I'll just note for the record that victim in this matter, Ms. Boss, did not want to be here today. She thought there was going to be, her words were, a lot of tension in the courtroom. But I've had good contact with her. She was happy with the outcome.
Mr. O'Keefe.
Your Honor, we filed a petition to defer the conviction under MCL 769.4A. It's my understanding that the people are objecting.
Judge Lee may have ended Cooley's antics with patience and precision, but Florida takes a completely different approach. Enter Judge Collier and Satavius Morris. The calm, measured approach here is fascinating, allowing the defendant to speak but firmly guiding the proceedings. Morris' sovereign claims take a dramatic leap into the fantastical, invoking cryptic references to the UCCC and citizenship rights. Watching these arguments unfold is like seeing someone mix legal jargon with science fiction. It's confusing, entertaining, and a little mind-boggling. And for viewers, it's the perfect reminder that courtroom strategy is as much about procedure as it is about personality.
So I would just ask that the court grant our petition.
I don't think I have authority to over an objection. I think the statute specifically gives the discretion to the prosecution.
And that was my understanding, Your Honor, of the statute. And to be clear, I am objecting.
Consent of the accused and of the prosecuting attorney in consultation with the victim. So it requires consent from the prosecutor.
I see. Okay, Your Honor. Well, given that they're objecting, I think the court's correct. It would not be able to defer the conviction under that, so I'll withdraw the petition.
Sure.
I suppose I'll keep the petition on the table, but given that they're objecting, I'm not going to ask the court grant the petition. Aside from this, Your Honor, the court heard all the testimony in this matter. I know the court has had a chance to review the pre-sentence report. I think the pre-sentence report is accurate. I think I would simply ask that the court enter an order adopting all the recommendations in the report. Thank you, Your Honor.
Mr. Sandell, what would you like to say to do for our sentencing?
Mr. Sandell is very nervous and he's indicated he does not wish to address the court at sentencing today. Thank you.
Okay. Brings to mind, the pre-sentence questionnaire, wherein he could provide his circumstances of this. He could have said, I had a trial, I maintain my innocence, I don't want to talk about it.